I'll be looking at matters surrounding, for example, removal under interim care. We'll look at really how the current line of authority on that is operating, looking at cases such as Rees-C, the 2019 decision, and some of the other ones. We'll look at Section 20 or 76, of course, in Wales, long-term use of that, where we are, the current Court of Appeal consideration of that, VW and VS. And like I say, best practice, we'll have a look at the position there, and most recently, as of July 2023, the President's views from his chambers, which ties in with the relaunch of the PLO. Now, issues over vulnerability are obviously significant in this area of law. So we'll look at participation directions, good practice when working with parents with learning disability in particular. We all know about ReBS, the 2013 decision, but we need to really look at more recent judicial jurisprudence on that. So I'll take you through HW, the number 2 of 2022 decision, and see how that ties in. Vaccinations, use of the inherent jurisdiction, we'll have a look at that, and then some developments surrounding fact-finding hearings and having further hearings when there are new allegations made. We'll see what the position is there. We'll discuss unregulated placements, some developments surrounding secure accommodation, the use of Section 33 when it comes to decisions that local authorities may need to take, and then towards the end of the session, I'll be looking at some aspects of discharge of SG orders. So quite a lot to cover in this webinar, and hence I'll be covering all of these elements throughout the hour session that we've got. Now, as I mentioned, there has been a lot over the years surrounding developments in so far as best practice is concerned. And with that in mind, we did have the Public Law Working Group final report and best practice guidance of March 2021. Many of you will be familiar with that. It set out a lot of proposals insofar as development going forward. So many of you will be aware that when it comes to social workers preparing their statements, for example, if, say, there's an urgent hearing, say it's an emergency protection order, maybe an urgent interim care, a short sweat, i.e. the social work evidence template, is sufficient for urgent cases. You don't need to do very long statements. A more fuller sweat, of course, would be required for longer term orders, i.e. when one is lodging an application for care and or supervision order.